Okay, I think we waited a few minutes, so I think we're just going to go get started. Okay, hi everyone, and welcome to AI and Law. Thank you so much for joining us today. Oh, I can see we've had a few more people join us, so welcome everyone. It's really exciting to have you all here with us today. So before I do begin today's presentation, I would like to start by welcoming you all to the presentation and also acknowledging the country that I'll be presenting from today. So I'm in Nyanjin, or also known as Brisbane, and I want to acknowledge the Turrbal and Yagara people who are the traditional custodians of the lands on which we are meeting here today. And I want to pay my respects to elders past, present, and emerging, recognizing that our First Nations people are the first inventors and creators who walk this land that we are so lucky to call home. So, hi, I'm Emily. If you're wondering who I am a lawyer here at Sprintlaw, and I am a self-confessed AI and tech nerd. I've just had a passion for technology since I was a little kid, but that's now moved into what I do, which is awesome as a technology lawyer, amongst a few other hats that I wear. And yeah, I've focused a bit on AI as well, both academically and also in my practice. So when I was at university, I did my honours thesis on artificial intelligence and law, as to whether or not we should be using AI to sentence criminals. So at the end of the presentation, I might tell you what the conclusion was that I drew from that. But yeah. So I'm from Sprintlaw. We're an innovative new law firm which provides all of our legal services online, which makes it really easy for businesses to access some simple, straightforward legal services. And yeah, we take the hassle out of finding yourself a lawyer and getting the legals that your business needs. Now, before I start, I want to do some housekeeping. So to give you an idea of what this presentation is, it's part current legal landscape, part gaps in the law, and part looking into the future. And even the parts that we're going to be talking about what currently does the law handle as it regards to AI, is a little bit tricky because a lot of it hasn't been tested yet. So to be clear, this isn't legal advice, and really, if you are looking to engage with AI, really will be in your best interest to seek a lawyer, maybe someone at Sprintlaw, who understands, the complexities of engaging with AI and law. Also, for anyone who along the way you have any questions about what we're discussing, feel free to pop your questions in the chat, or I know Zoom now has a Q&A function. Feel free to use either of those. We'll try to touch on some of those questions along the way, but we may also just leave them up to the end depending on kind of the influx of questions that we're getting. Additionally, if you have any issues along the way, we have a few team members here from Sprintlaw who can also help you out. So feel free to just drop a message to Sprintlaw in the chat, and they'll be able to help you out if there's any issues as well. Okay, so what are we covering in this presentation? So the idea behind this presentation was to provide an opportunity for people who wanted to understand a little bit more about AI and what it is, how it intersects with the law, and also, some real practical understanding as well of how that works as well, not just from, academic conceptual perspective. And then towards the end, we'll have some time for questions. Okay, so what is artificial intelligence? It's a pretty big question that's been going around, particularly if you look at all of these. I'm sure some of you have been seeing about Google's LaMDA and about whether it's achieved sentience or not. So essentially what's happened is Google has this piece of software called the Language Model for Dialogue Application. It's essentially a chatbot. And the developers that were working on the chatbot released a conversation that they'd had with LaMDA and said that the LaMDA had achieved sentience, it was aware of itself, and it created a lot of debate in the community as to whether or not this AI actually had achieved sentience or not. So what has really arisen from it, though, is that generally the community is the consensus that no, we really haven't achieved true AI yet. We don't have a sentient robot, and that's for a range of different complicated reasons. One of which is that really the bot is doing what it's programmed to do. So the bot was programmed to convince people that it was a human just having a conversation, and it did achieve exactly that. But that probably doesn't mean that it's sentient, that it actually has the self-awareness. And we also look at sentience as something that can expand to doing more than what it's programmed to do necessarily. So if you if you plug LaMDA into a Tesla car, for example, it's not going to start being able to drive that Tesla car as well. So can computers think? Probably not. True artificial intelligence probably doesn't exist at this point unless someone's cooking up something that we're not aware of. It can really be best described as machine intelligence or cognitive computing. These are some buzzwords you might have heard, where essentially it's a semi-autonomous machine that's still reliant on humans intervening, is able to learn and grow, but still has none of that sentience or self-awareness or real intelligence to work outside of the capabilities that the humans are intervening and instructing it to do. So, like I said, at its core, AI is the ability to mimic functions that humans associate with other human minds. So really, it's still an algorithm that a human has developed that's able to process things in a way that we'd normally associate with humans. So definitely a lot more complicated than existing technologies of, you tell a computer that if you receive this input, produce that output. But it's really not to that high-end degree of artificial intelligence. That being said, it is still incredible what we've been able to achieve so far. So AI services 5-year compound annual expected growth is going to be 37.9 billion by 2024, according to the International Data Corporation. It is a massive, massive segment of the industry that is going to radically change what we do, even as at the current capabilities of AI, it's absolutely incredible what it's able to achieve. And it's really important that we look, considering how it's going to start contributing so much to our economy, about how we draft laws that cover it. So I think understanding how does AI actually work will really help you to appreciate the way that all of these different areas of law are actually going to interact. And so that's what we'll be covering next in a very broad way. So, like I said, AI is a computer system, and essentially what we're talking about is something called machine learning. There's also deep learning and kind of various different degrees. But for those of you who aren't looking at, AI coding and who aren't interested in necessarily coding it, essentially what we're looking at is the ability for a machine to learn and be fed information and grow from that. Now, what does this include? So the technology can range from things like speech recognition to being able to problem solve, recognize patterns, process images, and the uses for that are astronomical. Everything from self-driving cars to Siri, the chatbots like LaMDA, and product recommendation programs as well. So if you've ever received an email from a company saying, hey, you should buy these products, it's quite possible that an AI was actually involved in deciding what those recommendations were.
Hey, Emily.
Yes.
Hey, sorry, I think some of the attendees are having trouble seeing the slides changing. I think the slides are still fastened for some of them. Yeah, okay. Just thought I'd let you know quickly. Sorry about that.
No worries. On my view, it seems to have changed.
Yeah, it's on the what does this include slide now.
Oh,
so maybe
okay. That's okay. Yeah. No worries. Let me know if that error happens again. Okay, I'm actually just about to change the slide. Could you let me know if it changes for all of you too?
Mm-hmm.
How's that?
No, it's still on the what does this include slide.
That's strange.
Okay, AI basic components.
Yep.
Yeah, perfect.
Okay, I think there might be a bit of a delay, so maybe I'll change early so that you guys are able to stay up as well. Okay, awesome. So this is how we look at AI very basically. So for those of you who joined us who are actually work in developing AI, I apologize for the oversimplification of how AI works. But to understand, the laws that we're going to be covering later, this is kind of how AI works. Essentially, someone programs a base program, they feed it data, and from that, it's able to become intelligent, as we know, and produce some sort of output. So for example, you could have a program like the product recommendations that we discussed before. So it has the functionality that to process the data from people making purchases of goods, and you instruct it saying, based on this information you're going to receive, you need to learn how to produce an output of a product recommendation. And then you feed it data and it learns from that. It starts to learn about people's habits and behaviors and what they tend to like. And if they purchase one thing, they're most likely to purchase this other thing next. And that's kind of how AI, generally speaking, works. And so these 4 key components are really important, especially when we're looking at things like intellectual property and liability, which is all topics we'll cover later, but understanding that there's something that a person has programmed, which is the base program. We input a bunch of data and it grows from that and produces an output. Okay, so now we're getting to the juicy stuff. So what we've actually come, a lot of you I'm sure has come here, which is about the key legal considerations for AI. Now, there are so many. This was really exciting to kind of summarize and put all of this together for everyone. However, it's really complicated and I actually struggled to be able to put everything into this presentation and still do it within the time that we had. So it's really interesting and it's a very broad range. We're looking at everything from intellectual property to who's liable when it comes to what AI does, and to how do we deal with personal information and the way that AI interacts with people as well. So there's lots of things to consider. Now, before we go ahead with all of that, generally speaking, for those of you who are actually operating an AI business, there are a whole suite of other legal considerations as well. And these are kind of some general areas that any type of business really needs to consider when they're looking to operate in Australia. So anything from intellectual property to employees and contractors, regulations that might apply to you. All of these things are really important to consider. Whether or not you're running an AI business, another type of technology business, or a regular business as well. All these things are really important. I've chosen today to not go too much in depth to this because this is really what applies to most businesses. So just be aware that, the key legal considerations we're going to cover are really AI specific because I thought that's what everyone would be really interested in. But there's a whole host of other things to consider as well, just in terms of operating a business. So definitely feel free to give us a call if you'd like to discuss any of those elements. Okay.
Emily,
yes.
sorry,
oh, no.
I still haven't changed. I think you may need to just double click. So one for the presenter view and one for the other so that it changes for both.
Yeah. It's changed. Okay, no worries. Has it changed now?
It's on the business setup slide. It's showing the Google Chrome view.
Yep. Yes.
With the address.
Yeah.
Is that fine?
Yes, that's the one it should be on. Okay.
Can you just try clicking quickly so it shows? Yep. IP protection. Perfect.
Okay, awesome.
Thank you.
Okay, so the first topic that I get asked most often when we're dealing with artificial intelligence is how does intellectual property work? I think also this has become really topical lately. For those of you who kind of keep up with AI news, you may have seen that there was actually an application for a patent for the inventor of that patent design to actually be an AI. So a company wanted to register the inventor of the patent as the AI, which was unfortunately in the end knocked back and wasn't able to be registered. But we'll talk a little bit more about that later. either way, intellectual property, really topical, really interesting when we're looking at AI. So there's kind of two sides to this. One is, well, how do we protect AI? And another part is, how does AI interact with intellectual property? So AI is such a new element. And so looking at the ways that we can protect the invention and ensure that, you know, the inventors of AI are able to protect their valuable assets is really interesting. So there's three key areas that we really look at when we're talking about protecting the intellectual property of AI. The first one is copyright. So copyright protects the original expression of an idea. So we're talking about the actual text in place. So let's say we talk about the source code. So as it's written down, it protects that. Now, the really tricky thing about AI is that copyright only protects the the written expression that a human has been involved in or substantially involved in. So as far as AI is concerned, where a lot of what is developed is not actually developed by a person, but is rather developed by the machine itself, brings to question as to who owns the intellectual property of the resulting material from an AI. So you may have heard of DALL-E, which is an image generator that a lot of people are using, and as to who actually owns the intellectual property of what DALL-E produces in the end. So essentially the way DALL-E works is you type in a prompt and tell it, hey, put together a photo of a chicken wearing a hat, and it will generate a photo of a chicken wearing a hat. The thing is, the machine has generated it, so who owns the copyright in the image that's created? So a recent example of this was an artist by the name of Tiger. Their album cover was actually developed by an artist who used DALL-E, and there was a bit of an uproar in the community as to who owned that copyright. And it's still not entirely clear because there hasn't been any sort of resulting legal case because of it. But it's a really interesting question as to who does own it. Now, there was questions about, you know, the fact that it was actually commercialized. And so was that appropriate considering it was the robot that had made it? So DALL-E has now actually changed their terms of service, which says, hey, it's fine if you want to commercialize the products that we produce, that's okay. But still really interesting in future, if they hadn't made those changes to their terms of service, what would happen? Now, we can look at other forms of intellectual property protection like patents. So patents protect an innovative solution to a problem. So for example, the patent protects the way the way a program makes a computer work. Now, it has to be novel, innovative, and maintained confidential until filing to be able to use a patent. But the idea is that it's protecting the idea and the function rather than the resulting product, the way that copyright works. So when we're looking at something like patents, we're talking about, you know, a solution to, let's say you're constantly, I'm looking around me and thinking, well, that maybe there's a way that a coffee cup works, and you're constantly spilling your coffee, so you produce a unique way to fix that. And that is what's actually being protected, but not necessarily the solution, but not necessarily the underlying material. So for something like AI, it's really difficult because we're looking at the way that the solution works, but not necessarily the way what was actually built in the way that we're doing with copyright. And so we're kind of reliant on the two of them working together to really protect all the different elements, because the copyright protects the code, but it doesn't necessarily protect the unique solution that the AI is solving. When we're looking at patents, it protects that unique solution, but might not protect a certain segment of the code or a certain component. So we're looking at these, you know, multiple different ways in which we can kind of protect AI. Now, last way is we're looking at confidentiality as well. So ensuring that you have proper contracts in place to maintain that your idea is confidential and that people aren't using your solution in a way that you're not wanting it to be used. And so there's a myriad of different ways essentially that you can protect AI. All of them aren't entirely perfect, but together you can kind of piece together a solution. It could also be that some of these solutions actually don't work for the particular type of AI, depending on how it's built and what you're wanting to get out of it as well. Cool. Okay. So what about AI generated works? So we touched on this before with the example of DALL-E and Tiger. So there's potential that also that AI actually produces something that infringes the work of someone else. Because a lot of these AI bots are scouring the internet for different sources, it could be that what they end up producing, if it's too similar to someone else's work, it could be that you're actually infringing upon someone else's copyright. So it's really dangerous. It's really something to be cautious of when you're building AI and looking at where you're actually sourcing your data from and ensuring that you actually have the rights to source that data. So I'm going to go to some photos next, which kind of clearly capture that as well. But another issue, and then also is with the intellectual property, is about who owns the IP of what AI produces. So like I said, that we have the case of the patent case, where they try to say that the AI was actually the inventor of the patent, and that was found that it couldn't be the case. You can't have the AI as the inventor of the patent. Similarly, under the Copyright Act and under a lot of different copyright legislations around the world, AI can't be considered the author of digital works. So they actually aren't afforded the protection of copyright the same way that if a person wrote something. Interestingly, the UK is actually an exception to that. They developed a piece of legislation that dealt with computer-generated works and actually do give copyright rights to works generated by AI. Now, there's some qualifications to that, and it's a different type of protection, but they still recognize that and put in place some legislation. So that's something that's, really interesting. Now, this is some of the works from DALL-E. So the one on the left is the example that I gave before of the artist Tiger's album cover. The example on the right, as you can see, is some generated images. Now, if you look closely, you can actually see the Shutterstock watermark and the iStock watermark on these images as well. So what it seems to be the case is that DALL-E has gone and actually sourced images from the public that were actually owned by the likes of Shutterstock and iStock, and it's actually picked those up and then inputted them into a lot of their photos. Now, really, it will be really interesting to see if, as they kind of develop in popularity, if the likes of Shutterstock and iStock would actually pursue this, because it would likely be against the terms of Shutterstock's license and that they present these photos. So a lot of the times you'll see in website terms and conditions that you can't go trawl through the data of a website and take the contents, and that you're not allowed to do, data mining, essentially. It could be found that clearly here's an evidence of the fact that DALL-E has gone and taken all of these photos, and that there's a potential that that could be seen as a breach. But once again, who knows what will happen and whether or not this will actually eventuate into anything. But it's really interesting to see very clearly where these photos are coming from. Okay, so we have then Davis. So this was the patent application recently that was blowing up in the AI community in Australia, because it was really interesting and exciting that originally with the application and the first court case, it was said that Davis, the AI, could be the inventor of this food container device. Now, unfortunately, since then, the court has confirmed that inventions have to have some sort of human action involved, and the inventor does need to be a person. amongst other things, their explanation for that was that the idea with patents is to encourage innovation, and an AI doesn't need encouraging in the same way that people do. So amongst a range of other justifications as well. But it'll be really interesting, you know, these kind of cases, it really shows that people are pushing and people want this, and it could end up being that the legislation could actually change, which means that AI in future could be considered an inventor. Okay, I'm just going to check if there was any questions about intellectual property. These are great questions. They're quite meaty as well. I think if it's all right with everyone, I might ask Reggie or Anna if you could look through the questions and maybe grab a few towards the end, just because they are quite meaty questions. So I just want to, I don't want to interrupt the presentation too much by reading through these questions. But thank you so much for all the questions everyone so far, and please feel free to keep sending, and we'll try to cover as many as we can towards the end. Okay, so next part, data and privacy. Now, this is also really interesting and really topical because of a few things that have been happening recently. So when we're looking at data and privacy, amongst a lot of other considerations, some of the main things we look at is whether or not there should be restrictions on automated decision making, or whether or not people should be made aware when decisions are being made that affect their personal rights by automated means. So we look at something like RoboDebt, for example, which created significant strife for individuals. That was made by a machine. Should it have been made by a person? Should there have been different kinds of checks and balances? Should people have been made aware that these decisions were being made by machines as well? Then we look at the right to process personal information. We look at the fact that a lot of machines, similar to DALL-E, scraping the internet for images, are also scraping things like social media for information about individual people, and what issues arise from that, from the existing privacy legislation around the world, and also moving into future, what we should do about it as well. The last bit we're looking at is data ownership and licensing. So not necessarily personal information, but a lot of the times AI businesses that are operating with commercial clients are engaging with data that is highly valuable to that company, and therefore you need to look at that data ownership and licensing and how should we handle all of that. Now, okay, so the recent case that was really interesting was actually 7-Eleven's use of a facial recognition software. So Clearview AI is a massive AI company in the US who actually trawls through the internet looking for the faces of individuals, and is able to develop profiles for those individuals, and I help identify them. There's a whole load of usage for this, obviously, everything from crime and using it as facial recognition and identifying individuals, to what 7-Eleven was using it for, which is a little bit more innocuous, which is that they were using it to, they had reviews that they requested from customers when they came in, and they had a little iPad, and on that iPad was a camera, and that camera would take a photo of the individual, and the purpose that they were using for was actually to ensure there weren't any double up of entries, because they didn't want to have one person making 20 different entries. They thought this is a great use of this technology. However, what they were doing with that is that they were creating face prints of people, which is considered biometric information under the Privacy Act. And therefore, they were actually found in breach of the Privacy Act by the Office of the Australian Information Commissioner. So they've since stopped using it. Now, it's come to light that a few other businesses have been using Clearview AI's technology. And there's also ongoing investigations into, for example, Kmart and Bunnings and their use of Clearview AI. Interestingly, the Australian Office of the Information Commissioner also then collaborated with the UK's counterpart in investigating Clearview AI, which led to them actually being issued a £7.5 million fine, because it was found that they were processing people's faces, and it was in contravention of the GDPR. So some really interesting usage of AI and interaction with personal rights as well, and something that people need to be careful of when they think, oh, well, this information is publicly available. People have, posted their photos online. It doesn't necessarily mean that they've relinquished all rights, and it could still mean that businesses are in contravention of certain laws. Okay, so automated decision-making is also really interesting, particularly because the Attorney General's Department commenced a Privacy Act review with the last government, and there have been some discussion papers presented, and they've suggested that they are going to require that privacy policies include information on whether personal information will be used in automated decision-making, which has a legal or similar effect. So that's really similar to what's actually in the UK and the EU GDPR as well, which already has that included. So if, for example, you're operating in the UK or EU, it's potential that you need to consider something like this, which is that if you are making decisions about people in an automated way, so using machines, whether or not it goes to the level of being AI, so that machine learning, or something a little bit more simple, still, if you're using an automated means and not having human interaction, there's the potential that you're required to actually give notice to people under the GDPR. In Australia, this isn't law yet. These are initial discussions that are being had and they're consulting on, but it'll be really interesting to see if this actually ends up going into place, especially because since the review started, we've also changed governments, so everyone's a little bit unsure as to what's happening, but we'll see. Okay, now going into liability. So it's a pretty broad topic to just call it liability, I realize, but there were some key things that I thought that were really interesting in the AI and law space that had to do with liability. One is being really careful about the warranties and representations being made as to what the AI achieves, especially when we're looking at things like predictive AI. So if AI is going out there and saying, we can predict whether or not a criminal is going to reoffend. If you are doing that, there are quite significant consequences of getting that wrong. And so being really careful of the warranties that you're making as to how accurate the information is, how you're putting it together, what the impacts are, really important to consider. There's also then bias. So Compass, for those of you who are unaware, was or is still a system that's used in the States to actually to decide on the sentence for criminals. This was actually part of the research that I did for my honours thesis as well. It was found that Compass was much more prone to mistakenly label people of colour as more likely to reoffend. And so it obviously had significant consequences if people are being sentenced to certain being sentenced based on the color of their skin rather than the myriad of other factors that the courts are normally meant to consider. So what if, as in terms of a more commercial usage, AI was used in hiring and was discriminatory? What does that mean for things like the Anti-Discrimination Act? It's quite possible that an employer who used an AI to make decisions on hiring and that AI was discriminatory, they could be found to be contravening the Anti-Discrimination Act because it turns out that the machine was choosing based on factors that were discriminatory. So on the basis of someone's gender or color, all those elements, it could mean that the employer is found liable. There's also the question of apportioning liability. So who is liable if something goes wrong with the AI? The AI is an illegal person, so who's to blame? And also, how do you even determine fault with the black box of AI? So we can talk about, well, there's the base program. So who did actually code the AI and who produced it? But also then if you say someone else produced all the data and provided the data to train the AI, are they liable? Or is it the person who's actually using the AI? Are they the ones who are liable? So really interesting case was back in 2018 when an experimental Uber vehicle actually struck and killed a pedestrian because they were an individual person who was walking a bicycle. Now, the machine hadn't actually been trained enough on detecting that and couldn't process who or what it was, because it wasn't a pedestrian and it wasn't a cyclist. And so because of that, there was a tragic accident that occurred. And there's the question of, okay, in that situation, you know, how do you apportion liability as well? So really interesting as to, yeah, what can happen in those scenarios. Okay, now we are going to touch very briefly on some contract drafting. And before all of you fall asleep, we're not going to be going too far in depth, but I just wanted to use this as an opportunity of how important it is to understand how AI works and how it's different to other forms of technology. For the example I'm going to give of an intellectual property clause, and how critical this understanding is to being able to draft a contract properly. Now, this, you know, this is something that's important to consider for those of you who are here who are lawyers, for those of you here who run an AI business, and also for those of you here who might be receiving an AI service. If these you know, intellectual property or any other clauses aren't drafted in consideration of the complexities of AI, there could be a lot of trouble. So this is somewhat of a stereotypical IP clause in a tech-based contract. Now, essentially what it says is that, you know, each party retains ownership of their IP, any developed IP, so anything that's created is going to be owned by the company, and the customer grants, you know, a license to their IP, etc. So that's a pretty standard intellectual property clause. Now, this actually won't work for a lot of situations, and here's why. So, for example, when we look at any developed IP will be solely and exclusively owned by the company. So what about if your AI produces something that the customer needs to own, for example, a translation? But the company needs to retain ownership of the modified AI. So if we're looking at this again, so the data feeds into the machine that makes it smarter, but it produces an output. Now that output is actually fed back into that intelligence as well. So how do you cover that? So you'd need to draft a clause that actually identifies these different developed IP as separate components. So it's not just that it was, you know, it's something that's being created through the course of this engagement. It's, okay, what specifically is it that, and how do we want to deal with the ownership? So another section, so the customer grants to the company license to use the customer content to the extent reasonably required to provide the solution to the customer. However, what if the company needs the customer's content to grow the AI and use it to provide the solution to other users? So like we said, the data is fed into that AI, and actually that AI grows and becomes better. Now, that content and has potentially some level of intellectual property in it that the operator of the AI needs. And so we need to ensure that the company is granted the appropriate license so that they're actually able to retain usage of the content to continue to use the solution. Now, this isn't always the case. It depends, once again, on how the AI is developed. There is a way that you can ensure that customer data remains kind of segmented from the rest of the AI, and so you're not reliant on this kind of big AI. However, you need to understand specifically how the type of AI is built. And a lot of AI is one big AI, and means that this kind of clause actually wouldn't work because the company wouldn't be getting the necessary license it needs to continue to operate their business. Last point is during the term, the company grants to the customer a non-exclusive, non-transferable license to use the solution. So what if the AI produces something that the company needs to license the customer as well? So when we talk about the solution, in this instance, the AI is probably the solution. However, the solution is actually producing something. So do we need to also cover that? And do we need to include that? And are we licensing it or are we assigning it? All of these things need to be covered and show that this kind of standard tech clause might not work in the context of AI. Generally speaking, though, what needs to be covered and what are we wanting to consider is the components. So remember, the base program, the data, the intelligence, and the output. Those are the things that we need to make sure are covered by the contract. And then as it relates to the IP rights, we need to look at things like ownership versus license, revocable versus irrevocable licenses, and whether rights are granted during the term of the contract or forever afterwards, and whether there are restrictions on usage or it's open-ended. So when we're looking at restricted or open-ended, I didn't touch on it before, so I just want to extrapolate on that a bit more, which is we're looking at, let's say, a company that owns the data, which is really valuable to them, wants to say, well, you can use our data for the purposes of growing your AI, but it can only be used for that purpose. You can't go and then sell it to someone else. So then you can put some sort of restrictions. So yeah, that's kind of what needs to be covered. And I think that brings us to an excellent point of being able to answer some of the many, many questions that we have. Reggie, have you had a chance to comb through any of these?
Yeah. So a lot of questions came in, which are not public yet because they're still unanswered. Probably the most common question that's come up is around privacy and consent if you're being recorded, whether inside or outside of a business premises. And in some cases, for example, Bunnings might have a sign outside which says that entry into their shop constitutes consent of the collection of that information. And we had a lot of questions around, I guess, what is the business obligations there and whether that kind of sign is enough to overcome consent requirements.
Yeah, it's actually really interesting that you bring that up, because that's kind of one of the questions that's being discussed at the moment, especially as it relates to Kmart and Bunnings, who were using AI to actually the facial recognition to look at their customers. Interestingly, we don't know in what all of the purposes that they were using it for. We obviously can look to their privacy policy and try to extrapolate from there, but that doesn't necessarily mean that's not only what they were using it for. And so, yeah, it's really interesting as to whether it's enough. The initial commentary being provided as to these examples of Kmart and Bunnings is that the entryway comments, that the entryway signs that say, by entering this store, you consent to XYZ, is not enough. The reason for that is, now, generally, is it enough when it relates to, I don't know, for example, you consent to the fact that we might be able to look through your bags and things like that. That I'll kind of leave separate. But as it relates to this specific situation, which is they were looking at those face prints, which constitute biometric information, like I said, the initial commentary seems to be that no, it's not enough, because it's that higher level of information. When you're using facial recognition software, you're using someone's face print, which is their biometric information. So it falls within what's considered sensitive information, and is therefore that higher grade of personal information that you require further scrutiny and further it's not further consent, it's probably not the best way to require it. You just have to have better checks and balances and ensure you're processing it appropriately and you do have the person's consent. So I think that's the element that was found to be insufficient in these, these signs that were outside, was the fact that they didn't, they were handling biometric information. As to whether or not that lower level of like CCTV and whether that was okay, that's probably, once again, without knowing exactly, generally speaking, you are able to record people on CCTV cameras for security purposes. It was because it was that greater level of using facial recognition software.
Yeah. Okay, thank you, Emily. We also had quite a few interesting questions from creatives and artists, particularly some questions on music industry licensing. And I guess it would be good if you could perhaps provide some general legal tips for artists.
Sure, no worries. So is it in relation to, like artificial intelligence using like artists' work and things like that?
Wasn't specified in the questions. We just had a few users waiting till the end to hear you talk about tips for artists. So I'll leave it with you.
Yeah, sure. There's probably, there's so many different considerations with that. It's, incredibly broad question. I guess in terms of for people who are performers, people who are, being paid for their services to go perform at a venue, things like that, is be careful of the contracts that you're signing and be careful of what those contracts say, especially for a lot of artists. I think, like I mentioned before about, copyright, that's kind of the intellectual property right that tends to cover a lot of the works that artists produce. And so one, it's great because the original, the way copyright works is you don't have to register it in the same way that you have to do with, things like patents. Copyright is, automatically owned by the person who originally created it, unless a few exceptions, like you're an employee, but I won't go into delve too much into the detail. But be careful of what you're signing over when you're entering into contracts as well. In the same way that, when we were talking about the intellectual property infringements of AI, and also looking at DALL-E. When you're entering into an agreement with someone, it's also possible that you just sign away your original rights in the artistic work that you've created. There's also, possibilities of these machines that are now scraping the internet for content and then producing new music based on other people's works. And so I guess to tie it into what we've been discussing today, it's really interesting, but also complicated as to whether or not if a machine, listen to your piece of music and then reproduce something, whether or not you have a copyright infringement. But yeah, I think in the similar vein to what I said before, going through that intellectual property clause before, is just be very careful as to what you're signing yourself up for. I think as, small-time musicians, there is the risk that you enter into a contract and you're kind of signing away all of your rights without realizing it.
Yeah. Thanks, Emily. And actually, there was a follow-up on that question that they were more interested in hearing about rights for visual artists, so I guess artistic works and things like that. There was also a question on whether there's a discussion happening in law right now about how biometric, just going back to what you were talking about earlier, biometric information. Someone's asked if there's a discussion around how biometric information is being stored and how it's being secured.
Yeah, sure, of course. I mean, there's a few different elements, and with a lot of privacy laws, there's actually, we have the Privacy Act, which of course kind of broadly covers privacy across Australia. Also, to clarify, I'm probably going to touch base on this on an Australian basis, just because the laws all around the world handle biometric information very differently. GDPR and EU particularly obviously have very stringent requirements as it relates to personal information. Within Australia, it's really complicated because we have this federal piece of law that covers personal information, biometric information as it relates to sensitive information, but also it's covered by each state and territory of Australia as well. And so there's in a lot of states and territories, there's some degree of a Health Information Act that regulates how health information is handled, biometric information, which could fall within that as well. And so as it relates to health service providers as well, they're covered by their own pieces of legislation. They have their own different obligations. And so they would also be covered by, their own like code of conduct as it relates to the health information they store. But yeah, it's really interesting whether or not, in regards to biometric information, it's a lot of the focus, I think, has been on the collection, and rather than necessarily the storage, is, I guess, what's most topical at the moment, because we're seeing so many people starting to collect biometric information, like I said, like face prints. And so that's a lot of the focus. There definitely are existing laws that relate to health information and biometric information. There's international standards that exist in regards to that as well. But I haven't, in terms of, what's new and topical in terms of storage, haven't come across anything specific so far.
Yeah, sounds good. Thanks, Emily. I might just do one last question. There are a few coming in. I'm sorry we can't get to everyone's questions. So this question relates to liability and risk. So someone's asked, what happens if a party creates AI software, so let's say self-driving software for cars, and then sells it to a wholesaler, which then sells it to a retailer, which is then sold to a customer, and that customer suffers loss, or something happens to them because they were relying on the software that was created by that very first person at the front. So can that end person who suffered that loss then sue the original creator of the AI software? And I guess what sort of protections can be put in place here to reduce the risk? And what would you recommend for these software creators who were the very first person there?
Sure, very good contracts is always one I always say. So yeah, I think initial perspective on all of this is that there should be agreements between the end person and the last person, like a chain of agreements. So you're, as the inventor of the software, are not going to necessarily enter into a contract with the end person. There is a way that you could. So depending on the way your software operates, sometimes we have what's called an end user license, and you put in place an obligation on anyone you sell your software to, that if they're giving it to someone else to use, they enter into an end user license agreement with you. And that covers kind of that, the risks mitigation there. Otherwise, you have a very clear contract between you and, I think the first person in that chain was a wholesaler. So between you and the wholesaler, having a really clear contract in place there that mitigates and minimizes those risks that, of what happens if someone does get hurt or something goes wrong as a result of the software that you've sold. Making sure that initial contract is very sound. That being said, depending on the industry that you're operating in, there may be manufacturer standards that apply to you. So for example, if you are manufacturing cars in Australia, there are standards that apply to you. And so there's then some of those you can't contract out of, and you can still be found liable. And so really it's a case-by-case basis. Like, what is your product? Do you fall within any legislation as a manufacturer of that product? And, we're looking at kind of like, and let's say it's a car with the AI in the car, does that fall within that as well? And understanding the scope of that, legislation. But also the other way is, having in place really solid contracts. And then also insurance is always, having in place good insurance to cover any sort of risks that your business is entering into is always beneficial as well.
Yeah, perfect. Thanks, Emily. I think that's all the questions we have time for today. And as mentioned in the chat, if anyone has any more questions, you can just email us there. Back over to you, Emily.
Yeah. Yes, feel free to email me. I'm always happy to chat about AI and law. It's yeah, passion of mine. So thank you so much, everyone, for joining.